couples looking into fertility options have a lot to think about. And if one partner is seriously ill or something unexpected happens to them, the decisions left to the surviving spouse can be limited without prior planning. In fact, all couples can probably benefit from planning ahead for those potentially difficult scenarios. Joining us now is Monique Chevalier and TD Wealth to enlighten us on some of the work that she's been doing. Thanks for coming in.
Great to be here.
So this is a hard conversation. I think often fertility is a hard conversation to start with too. There's a lot riding on it. And you have do work talking about estate planning for stored genetic material or embryos, which is a little bit different than, I'll say, regular estate planning. And when I say estate planning, this means obviously that somebody's passed, and so it gets very emotional and complicated.
Exactly. So many individuals these days are using assisted reproduction to build their families.
Yep.
So that's things like insemination, in vitro fertilization, surrogacy.
Yep.
And it's pretty common during the process and after to have stored frozen sperm, eggs, embryos that are at clinics. And one thing that's really clear is the law doesn't treat those in the same way that it treats other things that you own. And in fact, there's some court cases where lawyers were trying to argue about it using property law, and the court said, no, that's not the law that applies. And the reason is that in Canada, we have a federal law called the Assisted Human Reproduction Act. And that governs everything to do with assisted reproduction, including really specific rules around consent for use of sperm, eggs, and embryos.
And this consent, I know we'll talk more about this too, but this is written consent.
Written consent, exactly. And before I jump into the written, one thing I'll say is, people who use fertility clinics, they probably sign some forms with the clinic along the way, and they may think that's enough. But it may not be for a couple reasons. One, it may not deal with what happens when one of them dies. And we also don't have a lot of law that's really clear about whether that alone is enough. And so as you were saying with the written, the law is really clear that the consent has to be in writing.
And I just to double click on that one piece, because I've learned a lot as I've been getting ready to talk to you. But you would have a couple, they've made plans, they've discussed about how they're going to build a family together, and maybe they've discussed what happens if one of them is ill, if one of them passes. But even if they have agreed within the marriage verbally to each other, that's not enough.
Exactly. And that's where, the cases that have come up through the courts so far have generally been cases where there wasn't written consent. And so they're trying to ask the court to deal with that problem. But the results can be pretty heartbreaking. Both the BC Court of Appeal and the Ontario Court of Appeal have been very clear that the consent has to be in writing and it has to follow these quite specific regulations. So people will, if they've got stored materials, they really will want to speak to a lawyer to make sure that it's getting documented right, so that when the time comes, if the time comes, hopefully not, they'll be able to follow through on that plan that they talked about.
Well, let's talk about that. So, when you look at these estate planning situations, let's say there has been some assisted reproduction, and a surviving spouse, if one spouse has passed, decides to have a child using that stored genetic material. Maybe give a typical scenario and what needs to be true.
Yeah, so assuming they did that proper documentation and there is the permission to use that material, then we start to get into inheritance rights, which are provincial. But there are situations in a common scenario where, practically speaking, the inheritance rights of the children don't end up coming into the picture as much as you'd think. So for example, if you've got a couple, they own everything jointly, their home and their bank accounts, they're on each other's RRSPs and TFSs, all the things, and they've got a will and it names each other, then actually pretty much everything is going to go over to the surviving spouse. And the kids aren't really inheriting at that time. So when, the second parent dies, it's actually the regular parentage rules that are, determining their rights to that surviving parent's estate. And it's really, as I said, it's that provincial law that kind of kicks into play.
So do they have to have written consent with each other at that point, or would that had to have been in place already?
That would have had to have been in place already, but there's sort of like an extra step. So if you have situations where people do want to make sure, the surviving parent wants to make sure that that deceased parent is going to be legally recognized, maybe because, you know, the deceased person had left some inheritance separately for the children,
right,
or for emotional reasons they may want to make sure they're legally recognized and on the birth certificate. In that case, provincial laws apply, and for those that do have laws about this, there's actually quite specific requirements. So for example, you know, you may need, the surviving spouse may need to provide written notice to the executor or even to the court registrar within a certain time, like 6 months of death. The baby may need to be born within a certain time, 2 to 3 years of death. The person who died may have needed to give written consent, not just to the use of the genetic material, but also to be legally a parent after they died. Even in some provinces, they may also need a court order. So it's a lot of hoops to jump through, and that's a lot of hoops to jump through at a time when a person is grieving the loss of their partner.
Yeah, devastated, I'm sure, right? And yeah, no, it's fascinating, and you know, academically speaking, but when people going through it, it's so hard.
Exactly.
You've also highlighted that there are cases where outdated estate planning documents may be accidentally disinheriting children, grandchildren that are born with assisted reproduction.
Exactly.
And how would that happen?
Yeah, so outdated documents can be a real problem. So as I said, you know, provincial law defines that parent-child relationship and who's legal there. But lots of wills will still say, define children as biological or adopted, and haven't updated to include assisted reproduction. So you may have this situation where just because of the way it's defined in the will, someone's accidentally excluded. And really the answer to that is just to make sure that the lawyer is referencing provincial parentage law so that it's capturing the whole picture there.
And I'm trying to think, sorry, my head actually went to the practical experience. So if maybe someone's using, you know, donated sperm or egg in some case where that's not how it's defined, that would be one of these accidental disinheritances?
Exactly. You could have, taken a grandparent as an example. So grandparents, you know, their adult child may have had children using assisted reproduction, and they've got one of these outdated terms, and God forbid their child dies before them, it's going on to the grandchildren, but that grandchildren is not properly defined to be included. So it's just a caution when talking to the lawyers.
Interesting. Now, we've just talked about how you know, legal language matters in wills in terms of how a child is defined. But this also matters in terms of the legal language around a spouse.
Yes, exactly. And I've been using that as a generic term, but in reality, it depends on the province that you live in, and also that federal law has its own definitions as well. What
would happen in the case, I guess, when somebody who is not in a relationship or not in a recognized legal relationship, I'll put it that way, and they decide to, or they wanted to have children, they froze their genetic material and they pass, and their parents want to do something. What happens then?
Yeah, so unfortunately we have a bit of a gap in the law. So far all the cases have been about situations where there wasn't that proper written consent. So what we don't know is, in a situation where someone has really clearly properly documented their consent, that they want it to go to a family member, is that going to work? And there's just not that definitive answer. But what we always say to people is the law is always evolving, and the best thing you can do is to make sure that your wishes are documented as clearly as possible, because that gives the courts the best tools to be able to follow through on them.
Yeah, and I would say, just to echo that, I think it's best, your best wishes with, you know, written down where people who can help you do this, whether it's your advisor, your lawyer, everyone is working together to make sure you're getting the outcome you want.
Exactly. This is definitely one of those areas not to try to DIY. It's way too complicated. And so, yeah, working with an estate planning lawyer, someone who is familiar with fertility or is willing to get up to speed or reach out to someone who can help them, just to make sure that everything's properly done and those wishes are able to be, or have the best chance of being able to be followed through on.